Jeff Tenenbaum is a huge favorite of GSAE and the SAE community based on his incisive knowledge around nonprofit association law issues. Today, he's going to be focusing on the AI piece, but certainly there's a wealth of resources on the Tenenbaum Law Group website that I encourage everyone to go and explore further. I certainly know that as an association executive, I'm appreciative of the fact that it's easy to find things on the Tenenbaum Law Group website, particularly, maybe at midnight when somebody asks another question that I'm like, I don't know the answer to that, but they do. So without further ado, Jeff Tenenbaum is going to talk to y'all about things that are not as scary as they seem on the surface. So take it away, Jeff.
Thank you, Wendy, and good morning. It's good afternoon now, or morning to some of you, but afternoon to most. Thanks for having me today. So in 30 minutes, first off, I want to encourage you to ask questions throughout. Probably not going to be monitoring the chat box, so if someone poses a question, either just unmute yourself and ask the question, which is fine. I prefer that actually, or put it in the chat and Wendy can flag it for me, but no need to wait till the end. A lot to cover. Was just part of a CEO update half-day program yesterday on all of these AI issues for associations. Fascinating panel that I was on yesterday. Got into the weeds on some of these issues. Be able to just probably scratch the surface today, but this is a fascinating area of law. And by the way, I put in the chat our law firm's website, just tenenbaumlegal.com. And like Wendy said, we have a ton of resources there. Probably 150 different articles and PowerPoint presentations on kind of every leading association legal issue, and then tons of recorded webinars, probably about at least 75 on all different association legal issues, including an article about AI and associations and how to mitigate the legal risks, which is there as well. So first thing, and Kim's presentation was great, and what it, part of what it reminded me is that I had coffee this morning with someone from a client of mine who was in town from New York, and she was asking what I was doing today. And I said I was giving this webinar, and she said, I'm helping them form a new association, but she's not from the association world. And she said, really, like, do associations use AI? And I said, well, increasingly so, and increasingly looking at, various uses. And one of the things that Kim's comments, reiterated to me is that, you've all been using AI in different ways with different programs that have AI built into it. You just didn't know it. Really, I didn't know it either. And what I'll say is that not all uses of, and what we're really talking about is generative AI. Not all uses of generative AI pose the same legal risks. Like some of those things that Kim was talking about, if you're using, MailChimp to help you, sort your outgoing email systems and marketing campaigns and things like that, really virtually no legal risk, beyond whatever legal risks already existed prior to that. The use of that sort of an AI technology to me doesn't really pose any significant legal risks, but other uses do. And there's no question about it. And that's so I'm going to talk today about kind of the types of uses of AI. And I'm not going to be doing like a survey like Kim did of all the different types of uses, but what I'm going to do is kind of do a survey of the more notable legal risks. And like I always feel is most important, not only what are those legal risks, but what can you do to mitigate those legal risks? What are practical steps that you can take? Because some of these risks can be significant. Before I get into that, I do want to kind of flag one issue that came up because one of the panelists on my panel yesterday was an HR consultant, who's been working with associations on figuring out, like you heard Kim talk about how AI can make a lot of kind of monotonous routines much more time and cost efficient and free up staff time for other things. Of course, what we're hearing from a lot of folks and a lot of employees is, oh, what is AI going to run me out of a job because they don't need me, and what I do can be done, in 2 minutes by an AI platform, and it's a real concern. And I'm not here to talk about the ethics of that or what makes sense from a business perspective, but what I will say, it's a real issue, And, if associations want to get more efficient, to get more effective, to make maximum use out of employees, I would encourage you to not run away from that, to embrace it, to try to use AI safely and wisely in as many ways as you can to make your overall operations more effective and efficient. And then when staff time frees up from some of those tasks, retrain, repurpose those staff. This is what we talked about on the panel yesterday, to do other things that are of even higher value. And maybe they don't have the necessary skill set, but you train them on it. It doesn't mean firing staff. It means kind of repurposing them and training them for a higher level work that's going to deliver even more value to your members and more effectiveness for your association. So now, kind of moving into the legal issues, and this is interesting because we've been doing kind of a deep dive for some clients on some of this, and recently we had a large professional association client, national organization, that kind of had us do a kind of a deep dive into 3 of the leading AI platforms, which they're considering using. I'm not going to get into their line of work. But let's just say it involves putting out a lot of standards and, for their profession about, how practitioners in the profession should do things and not do things, and how the users of these services should utilize things. And so a lot of guidance for both for the profession as well as for the general public, all of which creates obviously potential liabilities for the association and whatnot. And they're trying to get a handle on, they had us look at ChatGPT, which comes from OpenAI, as you know, Bard, which comes from Google, and then a third one, which I hadn't heard of, but that's apparently becoming increasingly popular in certain aspects of the association world, something called Claude, Claude, which is actually extremely well known for its commitment to AI safety, security, and transparency. It's also HIPAA certified. And there's a certification called SOC2 Type 1 certified, which apparently has a lot of appeal as well. But the main takeaway from this analysis, or a lot of takeaways, but the one I want to talk about here is the fact that your legal risks are going to be affected by which generative AI platform you're using and which features of that platform you take advantage of. Now, granted, all this coming from me, who is the least tech savvy person. Well, not the least savvy, but I'm not a tech expert by any means. But what I will say is that I'm going to use the words inputs and outputs. So inputs are kind of what you put into the generative AI platform, whatever content, whatever questions, whatever data, that's the input. And then the output is what you get out of it. Okay. And then you all know that these generative AI platforms kind of produce, they get better, they get smarter by analyzing and utilizing all the inputs from everyone that gets put into their system in training their algorithm. That's kind of the basic tool of how they keep getting smarter and better and giving us better outputs. But a lot of the legal risks and a lot of the concerns come from what is going to happen with the inputs that we as an association put in. Well, interestingly, I learned through our work here that Claude does not use inputs in any way to train their algorithm. So it basically, whatever you put in there, it's just going to stay there between you and Claude, and Claude's not going to ever use it, repurpose it, use it for training its algorithm, use it for generating outputs for other users of Claude. By default, that is the rule for Claude. And if you're not a big fan of Claude, or you have no desire to use Claude, or maybe it's more expensive, I don't know that, ChatGPT and Bard both have features where you can go in and easily opt out of having your inputs utilized by ChatGPT. You just turn it off. And obviously, it's very important to do so. And I'm going to talk about the fact that if individual employees are at their desktops or laptops and they're using ChatGPT, they would each have to individually turn off that feature, and basically opt out of having their data analyzed and utilized by ChatGPT. But you could require your staff to do so. Alternatively, for larger associations, there's something called ChatGPT Enterprise. And I believe the other platforms have enterprise solutions as well. And this is designed for, and it's just like you have enterprise uses of Microsoft Outlook and other things like that. You purchase an enterprise solution for ChatGPT, and then all of your employees are utilizing that same enterprise platform. And the enterprise platform also has a default opt-out setting. So all of the inputs that all of your staff, if you're using the enterprise solution, don't get utilized by the platform anyway. So why is this important? Because some of the legal risks I'm going to talk about involve things like putting in sensitive data and potentially having it released out there into, the electronic universe, or putting in data that's protected by copyright that you don't want spit out to other people because it could end up infringing your copyrights. In fact, there's a current lawsuit by an association called the Authors Guild against ChatGPT for copyright infringement, claiming that the Authors Guild, which is an association of authors, actually used to represent them, that ChatGPT is basically scraping all of their content, their articles, their books, or things like that, and then spitting it back out there for others to be able to utilize. And by doing so, it's infringing their copyrights. Oh, and by the way, if you didn't know, something else I learned from this recent research, all of the leading platforms, if you go through their terms of service, which I'm sure all of you have read, there's an indemnification provision in there that says that if like ChatGPT gets sued because of some copyright infringing content that you put in there. So now I'm not talking about your own content, but to say that, and this has been happening for as long as I've been practicing law, where association staff go out there, find things on the internet, copy and paste it, put it in their own newsletters and magazines and journals and things like that. And then later, because there's these platforms out there that scan and analyze all the different content, it could be photos, videos, other things like that, you get hit with a cease and desist and a demand letter for significant money damages. In fact, there's this one law firm that does it all the time. We've probably gotten 25 letters from clients of ours that receive these. And some of these are very significant dollar amounts, and they are generally justified in their claims for copyright infringement, and they generally don't go away lightly. So this is kind of serious stuff. And so with ChatGPT, if they get sued because of some infringing material you put in there, they have the right to come after you. You have to indemnify them, pay their legal fees, any judgments or settlements against you, never mind paying your own defense costs and judgments or settlements. So it can be very significant. But the point is, if you're using either Claude or ChatGPT or Bard Enterprise Solution, or you turn off that, you opt out of them utilizing your data, it's going to significantly decrease the risk of your protected content being infringed by others, your protected trademarks being infringed by others. And even ChatGPT has said that they have no way of controlling it, that sometimes trademarks are going to, that are put in as an input are going to get spit out for someone's output. Now, that alone doesn't necessarily constitute trademark infringement, because that's a very different analysis than copyright infringement. It depends how it's utilized, but it's just a real reality. And so on that front, on sensitive data and other things, I strongly recommend that you utilize some sort of a ChatGPT option for your staff. And even if you don't want to spend the money for an enterprise solution or Claude, even if you're just going to allow individual users to utilize the regular ChatGPT 4, what you really want to have is a generative AI employee usage policy. And we've been starting to work on these for clients now. It says kind of, here's the rules of the road, right? Just like you have policies right now that govern, staff interactions on social media and other things like that. We've been working on those policies for over 2 decades. This would be a specific policy tailored to the use of generative AI by employees. And one of the things you can say there is that you are never to use a generative AI platform without opting out of their ability to use your data. That's one provision of multiple ones that you would put in there. That being said, I always believe in a belt and suspenders approach when it comes to legal risk management. And so at the same time, you also want to say, maybe the next provision in that policy says, you should never put into as an input anything that's sensitive, certainly that's subject to attorney-client privilege, anything that's confidential, and perhaps, or certainly nothing that infringes someone else's copyrights, and perhaps though not even putting in your own copyright protected information. So maybe, and sometimes it depends on how you're going to use it, right? Say you have a draft of an article that you've written and you want to get ChatGPT to kind of give you ideas how to make it better, stronger, more expansive, more insightful, whatever. Sometimes there may be a need to do that. And as if you have, if you've opted out of their use of that data, that input, that's probably a pretty low risk situation. But certainly you're not going to want to put in anything that's otherwise protected or confidential. And the same thing goes for data generally. Yes, these platforms can be terrific for analyzing data, but just be very careful that you're never putting in any sensitive, confidential, personal data, certainly no health, information, no personally identifying information about people. Just try to scrub that data as much as you possibly can before you put it in there. Even if you utilize that opt-out feature, it's just too risky from a data privacy perspective. All right, let me talk about a couple other issues too. One is employment discrimination. So you heard Kim allude to the fact, and you probably heard others talk about the fact that these platforms kind of just based on how they work. Actually, I forgot one thing on copyright. Let me go back to this for a second. This is really important. So, with copyright, we talked a lot about avoiding copyright infringement, but the flip side of copyright is copyright protection. And so if you're using, say, ChatGPT or another generative AI platform to help you generate content, and I even do it myself when I'm writing a new article. Sometimes I'll use it as a way to generate ideas. I'm a big fan of like top 5 and top 10 lists for articles. So sometimes I'll ask, ChatGPT, what are the top 10 legal risks facing associations for AI usage? I actually did that when I wrote my article about AI. It kind of sucked, but it didn't really give me everything that I needed, not even close, but it was a good starting point. It got my mind thinking, kind of get the creative juices flowing. And that's a well-recognized, I think at this point, after a year, use of this. But keep in mind, in the end, if you want your content to be subject to copyright protection, you absolutely do. Copyright protection comes when the creator of an original work of authorship, creates an original expression of ideas and fixes it in a tangible medium. And so, number one, the work to be subject to copyright protection has to be original. By definition, anything coming out of ChatGPT is not original. Now, the terms of use of ChatGPT do say that from a copyright perspective and an intellectual property ownership perspective, generally, you own everything you put in and you own everything that comes out. It makes that clear. However, we know by definition, this is not an original work of authorship because it's just a compilation of, finding everything else that's out there and pulling it all together to try to respond to your prompts and your questions. And so by definition, something that gets spit out as an output from ChatGPT or another platform cannot be an original work of authorship. That means you need to take that and work it further to create your own original work, original expression of ideas. And then another requirement under the Copyright Act is that the work has to be the subject of human creation. We don't know exactly what that means. The Copyright Office has put out a notice in the Federal Register a couple of months ago seeking comment on a whole wide array of issues relating to AI, which is kind of fascinating. We don't know exactly what that means, but we certainly know something that simply gets spit out as an output from ChatGPT is not the subject of human creation. So again, you need to put your own human stamp on that to really take what you get and work it enough to make it your own original work that is, subject of human creation. And then, as I've talked about in many other talks about copyright, you always want to maximize your copyright rights by using copyright notices, which is the little C with a circle around it, the year of initial publication and the name of your association on everything that you publish, put out on your website, in print, in electronic form, elsewhere, videos, recordings as well. And then you want to register your works with the Copyright Office, everything, again, websites, magazines, journals, videos, etc., within the first 3 months of an initial publication. It goes a long way toward maximizing your rights and enables you to recover statutory damages as opposed to actual damages in the event of infringement, and a number of other benefits as well. And also, some lawyers have been saying that if you're going to input any copyright protected information like And you get copyright protection simply from meeting those requirements I stated. You don't have to have a notice, you don't have to register it. So if you create a draft of an article, that is subject to copyright protection. Your association owns it because it's an employee doing it within the scope of employment, but it's already subject to protection. And some lawyers are saying, put the copyright notice on that before you input it. Because that way, if you end up seeing that someone else is infringing it, the ChatGPT and the other platforms actually have a takedown procedure that you can follow. You can request that that copyright infringing material be taken down. I don't know exactly how it works. I've never tried it, but it does exist. And they say if you use copyright notices, it's going to be easier to track that down. Okay, that's it on copyright, I promise. Now, employment and employment discrimination. We know that these platforms have built-in inherent biases because they're based on things that are out there on the internet and elsewhere that all have built-in biases. And so it hasn't quite happened as much in the association world, although it's starting to happen, what we're seeing with some larger associations, but it's certainly happening in the for-profit kind of Fortune 100, Fortune 200 world, where larger companies that hire scores of employees and have to screen, many, many times more of that of resumes and interviewees and whatnot, are increasingly utilizing generative AI to screen resumes, applicants for jobs, and even to screen recorded interviews. So you might screen a batch of resumes, narrow it down to a smaller group, pose the same questions to all of them, record their answers to those questions, and then use a generative AI platform to analyze their answers. That's happening a lot. It can be really efficient, potentially very effective as well, but you are by definition going to be perpetuating the biases that are built in to these algorithms that the platforms utilize to analyze this stuff. If you end up screening out certain candidates by virtue of that usage that has a discriminatory effect, and you're screening someone out on the basis, not intentionally, but screening someone out on the basis of some protected characteristic, or the platform is screening, recorded interviews, but someone has a very thick accent and it's hard, or speech impediment, and it's hard for the platform to understand what they're saying, the answer, so they end up getting screened out through the platform. That's very potentially problematic. So I'm not saying, and the platforms are constantly trying to root out bias, but it's going to be impossible, I would think, to do that anytime soon, if ever. And so what you really need to do is make sure that there's that human element that you are, maybe use it as a starting point, but don't just toss a resume or a recorded interview simply because the AI platform told you to. You want to have that human check and balance. It's really, really important. And I've heard some associations also talk, larger ones, of course, talk about using AI for volunteer management. Some associations have thousands and thousands of volunteers, even federated models where they have state and local chapters across the country, and they have this massive network of volunteers, and they want to sort and analyze and be able to take full advantage and see who the rising stars are and how can we plug these people in here or there. And again, if you're using generative AI to help you engage in that volunteer management, it's not going to really give rise to any legal risk because volunteers, board members those employment laws don't apply to them. They don't have that sort of protections. But still, it would be very problematic just from a member relations, a public relations perspective, if you ended up perpetuating biases in your volunteer management structure by your use of generative AI. So just be cognizant of that. Two other issues I want to talk about. One is something called tort liability. And Wendy, your daughter knows this well because you take torts in the first year of law school, which she's in the middle of right now. And she probably already took it or will next semester. So torts are kind of, I don't know, I probably used to be able to explain it better when I was closer to law school. But basically, say, you are manufacturing a product and you do it negligently, or you're performing a medical procedure and you do it negligently, and it causes some harm to someone. Could be physical harm, could be emotional harm, could be bodily harm, whatever it is. And someone can prove that you were negligent, or you were grossly negligent, or you engaged in reckless misconduct or intentional misconduct. These are kind of all different torts. And if you can prove the cause and effect and the resulting damages, these are the elements of a tort, then you can be held liable for that. And tort liability has existed in the association world for entire 30 years that I've been around this world, and many more before that, in that so much of what associations do, you put out a code of ethics for your members, like an enforceable code of ethics, or you put out standards that either are mandatory or you urge companies, people to rely on them and how they carry out their business in the industry or profession, or you have a certification or accreditation program where you're certifying individuals or products that meet certain standards, and you're essentially telling the public or the relevant segment of the public that these products or professionals are well trained and they know their stuff, and essentially a good housekeeping seal of approval. Accreditation is kind of the same, but with institutions. You are basically putting a good housekeeping, your association's good housekeeping seal of approval on those professionals, those institutions or whatnot. And then if they end up causing some harm to someone, they're negligent, they fall down on the job. Of course, that individual or that institution, if it's a hospital that gets credited, certainly they will be named in a tort lawsuit. But there's been scores of instances over the years where the association that certified or accredited the institution or the professional, or that set the standards, I think the 2 decades ago, National Spa and Pool Institute case where they got sued because they put out some voluntary standards about suggested depths of swimming pools that have diving boards in like residential homes. And a teenager jumped off a diving board, hit his head on the ground and got permanently completely paralyzed. And he sued, the family sued not only the swimming pool manufacturer, but the association that set the standards, saying even though there are voluntary standards, that the association was negligent in how it set those standards. It ended up throwing the organization into bankruptcy, the association. My point is these tort liability risks have existed forever, but those risks can be magnified or intensified if an association that's engaging in writing clinical practice guidelines or setting standards or putting out any kind of training materials, or you name it, anything that people, institutions are going to rely on that could end up causing some harm to someone, physical, emotional, bodily, whatever, at some point. You want to make sure that anything that gets the output that comes from that platform, that you are really doing your due diligence in vetting it and not just simply relying on it. And this is a very real potential issue. It's way too soon. I don't know that we've seen lawsuits arising from this yet, but I know we will in the future. And from a kind of prophylactic perspective, it's just going to be really important for your associations to make sure, again, you have that human element of making sure you're reviewing, scrubbing, doing due diligence on all the outputs. And then the last thing I wanted to talk about is insurance, right? We're, as lawyers, we're always preaching all sorts of things to encourage good risk management in associations, things you can do to mitigate your legal risk. But you can never stop someone from suing you, even if it's a baseless lawsuit, whether it's employment discrimination, whether it's a tort lawsuit, copyright infringement, trademark infringement, defamation, breach of data privacy, all of these things. And these are all types of suits that can and will arise out of associations' use of AI. You want and need to have good insurance coverage as a safety net, for starters, to be able to pay your legal fees. And unfortunately, there is no one type of insurance. There's not even, like for certain types, like directors, nonprofit directors and officers liability insurance, there's not even one standard form. Every carrier has a different form. And these policies, I've been reviewing them for 25 years. They vary significantly from carrier to carrier. And then each policy gets tailored based on your association's activities and structure. Like if you're a big publisher, you do a lot of publications, the D&O carrier is likely going to attach an endorsement, like an amendment that says, this policy won't cover copyright infringement and other similar claims arising, and defamation, things arising from your publishing operations. That's common, happens all the time. Sometimes there'll be exclusions for antitrust claims also, or sometimes the policies just won't cover certain things. To me, the goal with insurance is to minimize your coverage gaps. And that's where you really want to work with a good insurance broker that understands the association world and a good attorney that understands the association legal world to make sure you're minimizing those coverage gaps. So maybe you can work with your D&O carrier to purchase an endorsement to buy some of that coverage back in. If not, there's something called errors and omissions insurance, sometimes called media liability insurance, that will cover a lot of the claims that are not covered by D&O, like D&O policies, all of them exclude coverage for claims for bodily injury or property damage, just won't be covered. But E&O policies will. So if you're talking about some of these claims that could result in physical harm to someone, again, this is not just AI specific, but generally, you really want to make sure that you have a good E&O or media liability insurance policy that will cover and guard against those risks. And then, of course, last but not least is cyber insurance. It's so important. It's not going to guard against all these risks, but it is a very, very important policy, increasingly important. Unfortunately, all of these insurance policies are getting more and more expensive. They have been in the last couple of years, but this is no substitute for them. And make sure you have the right policies for your association based on its risks, that the specific provisions are tailored to your association, that you have the right policies overall, and do everything you can to minimize those coverage gaps. So 1 minute over, but that is AI and associations and how to mitigate the legal issues at this point in time in a nutshell. I'm sure when I do this 6 months from now, it'll be a very different presentation, but thanks for your attention.